Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, I will discuss about the defense strategy to be followed by the accused whenever he is caught red-handed. If you really want to understand, I request all of you to maintain the proper notebook with pen or pencil. Whenever you are having the trouble, you may easily take shelter from the legal knowledge you gathered from me. So, whenever we are implicated in a false rape case, what commonly mistake we have committed? We got panic. We are in the anxiety. We internally confess. We are not able to understand about your rights. Am I right or not? So, if you really want to get the solution, can you do one thing? Are you having fingers? How many fingers you are having? 8 and 2 thumbs. So, basically, we have to understand 10 important points whenever we are in a hot water of the anti corruption. More specifically, we are caught red handed. First of all, I request all of you, do not be panic or do not resist the authorities to do their work. Basically, whenever the agency inter alia caught you, they arrest you, you resist or you got panic. If you inter alia do all these activities, the concerned Anti-Corruption Bureau or Vigilance or CBI may take shelter to Section 35, Subclause 1, Subclause B of BNSS, by the virtue of which they may collect evidence against you and could convey the same to the Honorable Court, with the specification that the accused was not cooperating, he was threatening, and inter alia he resisted the arrest or resisted the process, and that's why we were left with no option except to arrest him. So in that scenario, section 35, subclause 1, subclause B of BNSS, even though infringe on their part, but you cannot take the benefit. So why we are doing such mistake? Please avoid. Got my point now? Now I'm coming on point number 2. Do not give the explanation in anxiety or at spur of moment. Because at that time we are under psychological disbalance. Can you do one thing at that time? Please note down the Brahmastra. Section 38 of BNSS, that inter alia gives you the right to consult the lawyer of your own choice. Simply, you could say, please call my lawyer. I want to consult before answering your claim. In this way, you may protect your rights. This is part and parcel of defense strategy. Point number 3, insist on documentations. Sometimes it is seen that they prepare document at their PS or at their office. If such a scenario occur and until it is observed by you, you may submit the same before the consent court by the way of objection petition. Every accused is entitled to subject himself towards a fair proceeding. If the proceedings are not going to be happened or not going to be occurred in the proper way as per the legal protocol, you may submit the objection. But whenever you submit the objection, submit the same point wise along with the specification, along with the evidences, and if there is any legal point, you may submit your case. And regarding the same, you may rely on one of the most important judgment of Honorable Supreme Court. Citation is 2016 SCC page number 277. In addition to this, if the witnesses are not on record and inter alia you observe the same and you are damn sure, in that scenario you may move as per section 94 of BNSS before the concerned court so that their call location and CDR could be preserved in case there is a clog on the location and it is evident from the evidences. Subsequently, you may easily call the document, means the CDR or the call location effectively, so that you could put your stand or defense on record as per the norms, which is also the part and parcel of defense strategy. Please be noted. As we know that in the case under section 7 of PC Act, demand is sine qua non. Mere recovery, mere acceptance could not help the prosecution. These are not my words. The observations are given by Honorable Supreme Court in one of the most important judgment, the landmark judgment titled as Neeraj Datta versus State of NCT. Date is 15th of December 2022. The court specified that the prosecution has to prove the foundational facts. If foundational facts are not on record, the presumptions could not be drawn. In addition to this, if there is mere recovery, mere acceptance, it could not help the prosecution. The prosecution has to prove demand. Demand must be specific and chain must be complete. If demand is not specific, mere asking for money, mere demand of money could not connect the accused with the accusation of demand of bribe. So this is important concern, please be noted. Now I'm coming on one of the most important perspective, because whenever you are caught red-handed, there might be recovery from you or from the article you are having. For example, the table, the almirah. If there is no recovery from you, you may take the additional benefit. In addition to this, regarding the acceptance, you have to give the plausible explanation. In addition to this, if the phenolphthalein test is not conducted on the spot, it is conducted after doing the recoveries from you. In that scenario, it is doubtful, as observed by Honorable Supreme Court in case of N. Vijay Kumar versus State of Tamil Nadu. Judgment date is 3rd of Feb 2021. In addition to this, they may compel you to give confession. In addition to this, they may ask you to submit your statement immediately. I request all of you to submit the proper statement. You may take the legal advice as per section 38 of BNSS, so that your effective versions could be on record. In case they fail to record your version as per the protocol of rule number 47 of CBC guidelines, you may take the additional benefit. So basically, whenever there is recovery from you, even there is acceptance from you, you are supposed to give the plausible explanation. If it is not given, the court may draw the adverse inference as per section 119 subclause Z of BSA. In addition to this, if you fail to rebut the demand in that scenario, the presumptions could be drawn. So to rebut the presumption, you have to raise the plausible defense. You are not supposed to prove your case beyond the reasonable doubt. And apart from that, you have to take certain theories, the theory of lending, the theory of grafting, and apart from that, you have to show the ill motive on the part of consent victim or complainant or accuser, that he inter alia having animosity with you, and apart from that, he is having certain illegal work. The work was not possible to be done in the legal way, and with intention to mount pressure and with intention to implicate false case, the present proceedings are initiated, and concerned ACB or CBI or vigilance, without verifying all the fact, inter alia involved you in the false case. So basically, we have to specify the way in which they have proceeded, so that we could put a clog on their fairness. And once it is shown that the proceedings are not fair, it is unfair, we could take the benefit. So basically, we have to see the legal compliances. In addition to this, if you are not caught red-handed, there is no recovery, there is no acceptance. You have to see whether there is any compliance of Section 17A of PCA or not. In addition to this, you have to see whether the sanction is accorded as per norms or not. In addition to this, you may see the compliances of important judgment of Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal, regarding the according of sanction. If sanction is cyclostyle, it is mechanical, you may take the benefit. And apart from that, your arrest is illegal, it is in violation of section 41 of CRPC or section 35 subclause 3 of BNSS, you may take the benefit. And apart from that, you have to see whether the grounds of arrest are inter alia communicated to you or not. If it is not communicated, you may point out the infringement of Article 22 of the Constitution of India. So basically, these are your rights, not of mine. So if you will respect your right, the chance to get them of being compromised, of being suppressed, would be on the minimum side. So respect your right, and whenever there is any infringement, proceed further and protect your rights. See you in the next video. Till then, Jai Hind, Jai Bharat.